IFERP, a forum where innovations and research interest could be supported and developed, prioritizing our mutual interest. In this video, we want you to dive into our world, giving yourself a clear insight into IFERP. But first, who are we and what do we do? Institute for Engineering Research and Publication, IFERP for short, is one of the world's largest non-profitable professional associations operating under the Techno-Elite Research and Development Association, TRADA, meant for research and development in the field of engineering, science and technology.
Operating under the Techno-Elite Research and Development.
Welcome to IFERP, a forum where innovations and research interest could be supported and developed, prioritizing our mutual interest. In this video, we want you to dive into our world, giving yourself a clear insight into IFERP. But first, who are we and what do we do? Institute for Engineering Research and Publication, IFERP for short, is one of the world's largest non-profitable professional associations operating under the Techno-Elite Research and Development Association, TRADA, meant for research and development in the field of engineering, science and technology. We are one of the largest professional bodies for engineering professionals in India and across the globe, established in 2014. We extend to every part of the globe, with more than 28,000 professional members and 34,000 student members. Our growing membership at IFERP has led to an increase in members from Europe, Asia, Australia, Africa and the USA, fostering networking opportunities that strengthen ties within and across countries and technical communities. The mission of IFERP is to connect professionals at an integrated platform for growth to divert knowledge and skills towards the sustainable application of professional education and more. And our vision of digitalizing innovation processes through our professional networking services and more has pushed us forward to our achievements today. With our mission to make our academic services reach the top and grassroots level of institutions, we are funding colleges to organize conferences and scientific events, enabling researchers incubated at different areas of our country to directly contribute towards the transformation of India. IFERP simply connects engineers, exchange global innovation, and acts as a bridge between researchers and academics by organizing international conferences, world conferences, faculty development programs, webinars, seminars, providing membership, and more. Some of our conferences include WCASET Malaysia, WCASET Jakarta, ICAS ETAM APU Malaysia, and many more. We've also organised scientific events in association with renowned universities done in the past, with over 28,593 journal publication services, creating opportunities to get your research paper published in high impact factor journals such as Scopus Indexed, Web of Science, Google Scholar Index journals, ESCI, UGC approved, L Compandax, ISI, Shimago Index journals, and many more. To make our operations smoother and more perfect, we have been supported by our associated organisation, Association of Cloud Technologists, Global Association of Nanotechnology, International Association for Big Data Analysts, International Association for IoT, International Wireless Network Association, and World Association for Structural Engineers. We have also worked alongside several clients and partners both nationally and internationally like University Malaysia Sabah, APU Malaysia, UNJ Jakarta, MC University Thailand, Ajman University Dubai, PUP Philippines, IIUM Malaysia, ISU Philippines, FCPC Philippines, WCC Philippines SRM University, Galgotia University, Amity University, and much more government and private organisations in different countries. At IFERP, we believe that there's always a better way to treat professionals, and that is what we do. If you would like to see more or go deeper on IFERP, you can visit our website at www.iferp.in.
Hello, everyone. Good evening. Hello, sir. Good evening.
Hi, Jazeela.
Yeah, how are you?
Good, good.
Yes, we have Mr. Pankaj Kumar also joined us here today evening. Hello, sir. Am I audible to you? Hello, both of you. Good evening. I hope you're
Good evening,
doing
Jazeela.
good.
Yeah, we are good. I hope you are
Okay.
doing
Yes,
fine.
yes, absolutely. And
Yes.
welcome everyone to our webinar series on intellectual property challenges in engineering, science, and technology advanced concepts. So today we have reached to session 3, and our speakers of the day, they are also over here. Welcome both of you. Today we'll be discussing on handling and management of IP portfolios with a focus on engineering, science, and technology. And before we begin, I would like to introduce to you our speakers of the day, Mr. Pankaj Kumar and Mr. Govind Kedia, a very reputed personalities in the industry. Firstly, I would like to welcome and introduce to you Mr. Pankaj Kumar, who is an intellectual property attorney, and he is also an registered advocate, trademark attorney, and the trademark facilitator and registered patent agent and the patent facilitator. He is also an academician at IIS, deemed to be university in Jaipur, India. Welcome, sir. Thank you for joining. And next, I would like to welcome our next speaker, Mr. Govind Kedia, who is the Chief Operating Officer and Managing Director at Arctic Innovation Consulting Solution Private Limited in India. Welcome, sir. He's also the finalist in Economic Times Young Leaders Award for the year in 2011 and 2012. Thank you so much, both of you, for joining us today evening.
Thank you, Jazeela, for having us here. Really
Yeah, it's an
pleasure to
honor
be
to
here.
have you, both of you here. And I would like you to speak a few words to our attendees who have joined us today for the third session.
Sure. So, hi everyone. Welcome to the session. Really great, initiative by IFERP and Jazeela. Thank you for having us here. I think I am very excited to be on the panel, and Pankaj and I got a chance to speak on the topic, and Pankaj would be taking over the first part of handling, and then I'll be talking about the management. Pankaj,
Sure,
over
sure.
to you.
Thank you, Govindji.
Thank you.
So,
Lights out.
yeah, we'll move on to the slides, sir. Pankaj, sir.
Yes.
Okay, so we'll move on directly to the presentations. Yes. Okay, so you may begin. It's all up to you. Yeah.
So whenever we talk about engineering, science, and technology, IP portfolio mostly covered patent. So this is a buzzword in the field of IPR. ठंडा बोले तो Coca-Cola. IPR means here mainly to patent, particularly in the field of science, technology, engineering. So patent economy, if you talk about it, market is whole world. Whole world is the market. You can operate your product or service around the world nowadays. Consumers having multiple options. Life of product or technology or service getting shorter because there is a lot of innovations, value additions. So life of such innovative products are shorter. Business promotion. In social media, we people creating links. So there is a lot of business promotion opportunities. In order to differentiate our goods or service, we use some
Sorry,
distinct
sir.
mark.
Excuse me, sir. Sorry, yeah, sorry to interrupt, sir. Your audio is not clearer to the audience, sir. Can you just clear your mic, sir, a little bit?
Just a
Hello?
moment.
Yeah, sure, sure. 。
So in present time, we can sell our image, concept, ideas. We do outsourcing the things. There's no need to do all the business steps by single person. As per need, we can outsource multiple things. So economic significance, efficient use of resource resulting in lower cost, improved process. Whatever service you perform, you can do. Rest you can outsource. So this is the time of innovative goods. We need to evaluate in our goods. IP. What are the subjects of IP? I think you must aware so far that literary items, fine arts, marks, designs, inventions, software. These are the subjects of IP, intellectual property. Mere having IPR, legal rights, doesn't help unless you commercialize it. So nowadays, a person's financial position determined, including by its ability to commercialize its intellect. Intellect, that is intellectual property. So IPR are not only a legal assets. It represents a commercial value and may thus be a financial instrument. We need to sold it, license it. It can be mortgaged. So there is no any benefit unless you put the things in the market. Society can get benefits only once you put the things in the market. Mere having IPR doesn't help. This is a very big problem in academics. They generate intellectual property. Somehow they manage intellectual property rights, but they fail to commercialize it. I think you must experience such things. During the commercialization, either we assign the property or we can license it. During the licensing, there is an agreement. As per the agreement, there is a royalty terms. There are many laws of IPR. You can say significance of the IPR, like it increase the value of the person, whether it's an individual, academics, company. So IPR being intangible assets from substantial part of assets of a company and thus increase the valuation. Better IPR portfolio gives competitive edge. It indicates company reputation, image. You can commercial it by selling, licensing. You can negotiate. You can get better bargaining position. You can.
Sorry, sir. Sir, the voice is again getting interrupted. Audience, they're not able to hear clearly, sir.
I can try. Hello?
Yeah, now it's clear, sir.
Okay, thank you. So, significance of IPR, it indicates reputation of a company, individual. The IP who generates get recognition, get value, he can assign or license out their IPR. If we talk about asset value in company, chronologically it increases. In year 1950, there is only 20% intellectual property assets in a company. In 1990, it becomes 20%.
Pankaj, sorry to interrupt again. Your voice, maybe you your internet connectivity or something is wrong. We are not able to understand. It's very cracky. Sometimes when you are sort of pausing, it is coming fine, but when you're speaking, it's like not very clear. So I don't know what's the problem. Jazeera, you have experiences earlier, so I'm not sure.
I think it's because of the network, sir. Sorry, attendees, when they have been telling it's not clear, but it's because of the network issue, I guess.
Okay, let me try.
Okay, sir.
I think most of the things in PPTs are well expressive.
Yes, it's clear now. You may continue.
Okay. In the present time of pandemic, we can generate revenue by means of idea. Now we are receiving a numerous queries to filing IP applications like trademark, copyright, patent, designs. So in 3 times of difference, but they have numerous ideas. So they need to protect such intellectual property. And by means of getting such monopoly rights, legal rights, IPR, they can generate revenue. So this is the time to acquire IPR. I think this is already clear to you because that for innovative products and process, the concern IPR is patent. Or in some countries, you can similarly also import some minority products. Similarly,
Sorry, sir. Sorry, sir. Sorry to interrupt again. Sir, can you just rejoin the link again? Maybe there is some problem with it because you're not able to hear properly. You can just
Okay.
close and join
Sure.
again and see. Yeah, sure.
Okay.
Sorry, participants, for the interruption in between. We have been receiving that you're not able to clear properly. So it was just some kind of network issue. We'll be back soon. And meanwhile, we have here Mr. Govind Kedia, sir, here. So are you online?
So I'm here.
Yes, yes. Yes, sir. By the time Mr. Pankaj joins us, you can just share your entire journey coming till today. I think you have been a finalist in 2011 and 2012, and it's not very easy to achieve that.
Sure. No, thank you. I think my journey goes back in the IP since 2006, where I got interested in the topic and fortunately started to work with a company called CPA Global. And I was fortunate to be part of the team, which was very, very innovative in terms of what we can do with IP. And in that journey, I was able to sort of look through a lot of facets of IP, including valuation and how to optimize the portfolios and how to really make use of your patents in a real world, and was able to help a lot of R&D companies around defining their technology landscapes and so forth. So that's how my journey has been. 2011, 2012, of course, it was a moment where I have sort of started Arctic Invent with a few collaborators in UK and Finland, and since then we have been helping a lot of companies. I think Pankaj is back. I think I'll not steal his thunder and then maybe talk in my sort of slot. So Pankaj, you're back.
Hello, sir.
I think Pankaj is still, yeah, he's back.
Hello. Hello.
Yeah.
Yes, sir.
Is it okay?
Yeah, when you speak continuously, there is some kind of interruption. Otherwise, it's fine only, sir. We
Okay.
just
When you
try.
speak slowly, it's fine. Yeah, I think sometimes when you speak, maybe the network is not able to pick up the data.
I understand.
So yeah, so just keep it slow. I think it will be fine.
We'll try
Okay.
again, sir. It's okay. Sorry, participants there. We are back. Sir is here. So you can continue, sir.
All right, thank you.
So there are different kinds of intellectual property, and accordingly there is some kind of IPR. Like for inventions, there is a patent for artistic retrievers, drama, music, artistic things. There is a copyright and related rights for a look of a goods that is designed, maybe creative or aesthetic. We can protect it under industrial design. So similarly, science, a person used to differentiate their goods or services, such science or mark can be protected under trademark or service mark. All service mark are trademark, but all trademark are not service mark. Similarly, for microchips, there is a layout design of indicator circuits for denomination of goods attributable to a geographical origin. There is a GI, geographical indication for confidential business information, the information which have value, commercial value. We can protect it under trade secret. For plant variety, there is a plants and breeders, farmers' right. They are X as per the IP and IPR, different kinds of IPR, so there are different kinds of act. Time to time, they need to amend it. If we cover all the IPRs in one table, the table would be such kind, where you may find IP that concerns an IPR, who is the innovator or creator, the designation for them. So you may find there different aspects like laws, authority, where the headquarter, criteria based on that, such IPR is to them, term of protection, term of renewal. You may find all such things in this one table. So IPR system whether underutilized or utilized adequately. I think you must guess underutilized. Enterprise worldwide largely underutilize the IP system due to perceived lack of relevance of the IP system, high cost, complexity, limited, inadequate awareness of IT system, its usefulness, lack of qualified professionals, human resource. So these are some of the aspects we can say it's underutilized. In order to manage and admin IP, we must appreciate IP life cycle. There are various stages. Idea to incentivization. In order to motivate a person who having some idea, having commercial validity. When idea doesn't help, you can't protect the idea. You need to work out over your idea. You need to express your idea. So you need to create idea to create. Once you create the things, in order to monopolize, you need to get legal protection. Legal protection, that is IPR. Legal rights for the concerned IP, you need to protect such IP. Once you get the IPR, you need to maintain it. You need to renew. You need to watch due diligence whether someone is using your IPR without your consent or not. Commercialization. Mere having idea, IPR doesn't work unless you commercialize. Otherwise, it's simply a paper document, a certificate. This is not the purpose of IP system. This hardly motivates a person who invests so much time, efforts, money in order to create and getting such IPR. So you need to commercialize. Once you commercial, you need to enforce. No one doing such commercial or your IPR without having prior consent. So you need to enforce it. Incentivization, the stakeholder, the inventor, the creator, artist, whoever creates such intellectual property. You need to recognize them, incentive, so that they can motivate in order to create further intellectual property. Creativity and innovation. It helps human development, economic empowerment. It is easily stimulated by IPR, intellectual property right, so that the right holder can enforce their rights and make money. So knowledge is the main driver of development. In year 2016, we have national IPR policy for the benefit of all, covering innovator, creator, artist, general public, academics, companies. It covers all in order to promote advancement in science and technology, arts and culture, biodiversity, and the related additional knowledge. These are 7 objectives of national IPR policy. If you recall IP cycle, you find all these objectives inspired from IP life cycle. Idea, generation of IPR. Here, IPR awareness. In order to know what you have, you must be aware about IP you having. Knowing to own. You hardly owe a property you don't know what you already have. So you must aware. So this property helps to outreach and promote, to create public awareness about the economic, social, cultural benefits of IPR among all sections of society. Further, to stimulate generation of IPR. Once IP generates, we need to protect it. So the third one is legal and legislative framework. To have a strong and effective IPR laws which balance the interest of right owner with larger public interest. Administration and management to modernize and strengthen service-oriented IPR administration. Commercialization of IPR. Actually, I think this is one of the most important aspects of any of the IP policy and in the IP life cycle also. Because if you unable to commercial your intellectual property rights, there is no any help. Mere having IPR hardly helps. It's a number game. Enforcement and adjudication. To strengthen the enforcement and adjudicatory mechanism for combating IPR infringement. There is a lot of case piracy, infringement, passing off. So there is a burden over the right holder to watch whether someone copy or infringing their IPR. Human capital development. In order to create further IP and to protect such IP, we need to develop such relevant skills in the human. To strengthen and expand human resource institution and capacities for teaching, training, research, and skill building in IPR. Under this national IP policy, there are some further schemes, both at state level and national level. One of the schemes is SIPP, a Startup Intellectual Property Protection, where there is a 50% rebates in trademark fee, while for companies it is 100%. So they treat a startup like a baby, like an individual person, a natural person. So earlier there are three kinds of applicants. Now applicants are three kinds, but the fee for both either the individual applicant and the startups. Similarly, there is a rebate in patenting. There is a provision for expedited examination and disposal of patent application. Under this SIPP scheme, they are IP facilitator, like patent facilitator, trademark facilitator, design facilitator. You can get their services to file IP application. You don't need to pay him. You need to pay only the government fee. And so at the subsidized, the government bear entire cost of the facilitator who assist you, particularly in the case of startups. Similarly, there are some TISC, Technology Innovation Startup Schemes. Other than startups, even academics, individual person can approach such TISC. They can assist you to filing, and further, you don't need to pay any professional charges. So if we talk about handling and management of IP portfolio, with a focus on engineering and science and technology, these are some of the issues. What management of IP portfolio? prerequisite. What action needed when managing such IP portfolio? Decision making, filing strategies, sets. In IP management, first of all, we need to identify what kind of IP we need to protect, what kind of IP we need to open in open access. For which time we can do renewal of such protected IP are what IP we can commercial, what IP we can license or assign, how can we generate funds out of such commercialization, how can we invest such funds to create further IP. So these are some of the things for which we need to manage IP in our research and development. Evaluation, protecting innovations, reaping value from research, attracting research fund, creating incentive for the inventors or institution, award and recognition for such person, establishing collaborative project with industry, academia, industry linkage. Impact of such intellectual property over the society. Depositioning the institution by means of getting value, recognition, funding, your institution can reposition. Hello. PPTs are not coming.
1 minute, sir.
Yes.
Is it clear now, sir?
Yes.
Okay.
So in order to manage IP portfolio, first of all, we need to perform IP audit. More about IP audit, our next speaker will deliberate over the same. We can get inputs from experts like IP attorneys, legal sales, IP sales, researchers. We need to identify various kinds of IP, and ever we can create various portfolio like patent portfolio, trademark portfolio, design portfolio, copyright portfolio. Most of us heard about IP cell, IPR cell, technology transfer office, IIC, institution innovation council or institution innovation cell, institutional IP cell, TISC, IPFC, intellectual property facilitation cell. So more or less, all such cells having almost common objectives and functions. This helps to handle and manage IP portfolio, to integrate IPR with educational process. They can suggest to update the course curriculum, to insert 1 or 2 units of IPR in a particular paper, like research methodology, to propagate a culture of regards and respect for IPR. If we are not aware about IPR, how can we respect IPR? To facilitate resources like databases. Databases are both free and paid. We can access such prior arts database using such IPRs and facilities to ensure speedy and accurate identification and protection of innovations arising out of the research work carried out in the university. In order to file IP applications, particularly patent applications, we must do some prior arts. This can save a lot of money, time, efforts to facilitate transfer of knowledge, technology transfer from university to industry. The cell also aims to offer assistance to grassroots innovators. It depends on institutional policy whether they are interested to support outside persons or not. For an example, in my university, IST, named to be university, we have institutional IP policy. You can access or download this IP policy from this web link. We have some intellectual property. You can access our registered intellectual property over that link. We have some events on IPR. So the objective to see, mostly these are the common, like for any of IP cell. These are some of the services or functions of IP cell, like assisting departments, various departments of the university to develop and introduce course curriculum on IPR, like career-oriented development, certificates, diplomas, best career system CBCS under the UGC, conducting IPR outreach activities, celebrating World IP Day on 26th April, counseling on career opportunities in IPR, career assistance and guidance on preparation of patent examination, trademark agent examination, direct women scientist scheme, providing assistance in scientific research and development, to providing the latest publications and patents on the subject. Prior. Providing prior reports to analyze intellectual property. This helps to identify patentability requirement or registrability requirement of tag application. Drafting services, drafting patent specification, preparation of document for filing any kinds of IP, under the follow-up, post-filing requirements, facilitating IPR services including outsourcing, coordinating with experts like outside advocates, agents, for various IPR needs, including IPR box services, opposition services, litigation services. This is the most important slides in this PPT. It gives a lot of tips. We must have on publication of our research. Once our research published, it may perish. It lose the patentability criteria. So we must keep it in mind. If you are interested to protect it under IP system, particularly patent, we check the criteria of patentability. And once it approved from IP cell, then we consider accordingly whether to go for publication earlier or to file a patent application. I suggest if you have patentability, you go for both. Once you file a provisional or complete application, next day you can publish your research. Prior research, this is a continuous task. Although this is not mandatory, but it helps the institution or the innovator to save their time, money, resources. Who can be the applicant? In many academics, it is not clear who can be the applicant. Sometimes institution themselves as an applicant, and somewhere they are researchers as an inventor, in the capacity of both applicant and inventors, and somewhere both institution and the inventor. I think third option is the best option, where both can enjoy the rights of applicant. There is no any harm including inventors along with the institution. Obviously, if application filed from the institution will pay. Institution thinking once they are paying, they will be the applicant. But there is no any harm to include inventors. Actually, it gives some motivation, recognition to such inventors. So applicant may be included, both all the inventors along with the institution. In the case of inventor, institution can't include it because institution is not a natural person. Only a natural person can create inventions. Regarding the fees, there are two kinds of fee: government fee and professional fee. We need to pay government fee, but professional fee, there are some government schemes as discussed earlier, like TISC, SIPP scheme. We can get facilities from them. We no need to pay any professional fee. They can serve. There is a panel of IP facilitator. We can get their free services. Many times they suggest for different kind of services a list of panel we can access such facilitator. There is a concept of NDA, non-disclosure agreement. If you desire, you can do it NDA with such IP facilitator, patent agent, or IPFC, so that you can assure no one can leak your invention disclosure. What you disclose with them. Deadlines. Many times we miss deadline, and it could be fatal. Our application may abandon if we didn't comply deadlines. If we file a provisional application, there is a timeline of 12 months, 1 year to complete it. If we didn't complete within 1 year, it will abandon. Further, there is a timeline for publication. It published after expiry of 18 months. If you're interested, you can pay and request. Then it may publish within 1 month. Otherwise, you have to wait to expire 18 months at least. Again, there is a 4-year timeline to make a request to examine your patent application. Sometimes you may forget to request for examination. It's not automatic. We have to make a request. Without request, in time, the application may abandon. Unfortunately, IP practitioners missed to inform the clients in time. So innovators, applicant, institution need to follow up such timelines. Otherwise, you get such loss of LM, your application. So publication is optional, examination is mandatory. Once the examination is issued, there is a 6 months to respond it. I suggest never wait for 6 months. Do it at the earliest. After responding the examination report, we need to follow up. There may be an opportunity to renew to hearing. Nowadays, the hearing is accepted by teleconferencing. Once the patent granted or any other kinds of IPR like trademark, design, we can renew it. Patent can be renewed up to 20 years from the date of filing or the private which is earlier. While industrial design is for 10 years, we can renew it for one term, 5 years. That is total 15 years. Copyright generally given for whole life of the author plus 60 years. So they don't need to renew it. Actually, there is no option to renew it. In case of trademark and GA, there is 10-year terms. You can renew it for further 10 years and continuously so on. So in-house control, external agent may not be liable seeking their instructions. At least one of the person institution may be given such duties. That's why there is a concept of IP cell, where there is an IP coordinator to coordinate with the outer experts to follow up all such deadlines and compliance. Lastly, all such things make wasted if you unable to commercial your intellectual property rights. It may help you on in NEC accreditations, recognitions, but the ultimate purpose of IPR is having monetary gain. Unless you commercialize it by means of technology transfer, assignment, licensing, there is no any actual benefit. Lastly, we need to maintain due diligence and freedom to operate before launching our protected items in the market. We need to check whether we infringe others' IPR or not. Opposition, pre-grant opposition, post-grant opposition, infringement, question notice, legal notice, litigations. So we have to keep all such things in mind. This way we can manage our intellectual property. Intellectual property, either of science or engineering field or other way. We can report some of our institutional person for further training in the field of IPR. One of the such training institute is National Institute of IP Management of Government of India. It helps you for such relevant skills. There are so many papers about the intellectual property management. If you read out most of the paper discuss about IP audit, IP valuation, commercialization. So this is all about IP management. In any of the scientific engineering institution, we need to audit our intellectual property. We need to value, we need to commercially. IP audit for efficient intellectual property management of an organization. It becomes mandatory for academic institutions to change their focus from knowledge sharing to knowledge capitalization. Earlier, we believe in open access. What does it mean of university? Universe. Whatever the knowledge created inside the university, that will put in open access for the benefit of whole universe. But nowadays, there is a concept of monopoly, capitalization of knowledge. This is very important. Managing intellectual property, we should link academic research with industry so that there is no problem of commercial viability. Whatever the demand of industry, whatever the demand of market, we can do relevant research so that research output can be commercially viable. It must be in demand in the market. Only then we succeed to commercially to any industry. So why not club with industry? Whatever the demand of industry, we can do such research rather than general research. It is observed that from various organizations, that there are strong scientific capabilities, but there is no adequate academic university industry collaboration. There is a weak industry science linkage in the country. Hence, there is a need to develop internal IP management capabilities. The formulation of comprehensive national IP policies, strengthening their IP code system and IP officials, enforcement mechanism. The interactions shall take place by the licensing of patent, research and development collaboration, scientific publishing, and participation of conferences. Use of audit to optimize patent life cycle. We can say a lot doing such IP audit. What need to be protected, what not need to be protected, what need to be renewed. Thank you.
Thank you, sir. And with this,
Thank you, Pankaj.
Come to the end of Pankaj sir's presentation. If you have any questions, you can write to us in the chat box. And we are sorry about the audio issue, but I'm pretty sure the slides are very clear. And if you have any questions, you can write to us. And without any delay, we'll move on to Govind sir's presentation. Sir, shall we move on to the presentations?
Sure. Am I audible clearly?
Yes, yes.
Yes.
Yes, sir, you may begin. Thank you. Yeah.
All right, Jazila. Thank you, Pankaj, for building a great context for me. So I'll be talking to you more about the handling or the management of side of the portfolios. Share some insights about how we do it, what are the tools that we can use to do it. So I'll just begin with short introductions. Of course, this is me. I'm an IP engineer. Worked with more than 200 companies or so. Presently working with 50+ team members based out of Noida, and some of the team members in Mumbai and Bangalore. I've worked on various facets of IP. I'm very passionate about automation tools and how automation can really change the IP. And I have this mantra on IP is that innovate fiercely. That means that you can innovate very fast, or you should innovate very fast, and invent fearlessly, which means that when you are inventing, you should not be fearing about copying or other things. So speed and fearless is the mantra that I feel that IP can actually help you in in your research and development or taking your business to the next level. So let me do a quick refresher before I begin, and of course also build on what Pankaj has really already said. So just a kind of a myth buster here to start with. A lot of times we get confused with intellectual property, with intangible assets, with intellectual property rights, right? Now that is not equal, right? I mean, these are the things that is different in the context. Intellectual property is something which is not tangible in a way. It is coming from your brain, or somehow it is not tangible, and then it's a property. If it is valuable, then it may be called as asset or a capital. It could be human capital also. Intellectual, you cannot see an intelligence of a person. So intelligence is an intellectual property, right? And if that intelligence is really useful, then it's an asset. But can you protect that as a intelligence, as a asset? That is something that you should be sort of not confused with, right? So intellectual property rights are pretty clear, in a sense that these are typical rights which are legally enforceable, which is trademark, copyright, design, patents, and trade secrets. Trade secrets, of course, there is a Secrets Act and all that, but not really registrable. But of course, these are real. In a way, it gives a tangible form to your intellectual property. So these are intellectual property rights, so to say, right? Then, what is business? So if you look at and try to look at very granular level, or high level. Sorry, not a granular, but let's say high level in terms of business is basically it's about production plus selling plus support. Right? That's a business enterprise. Nothing more, nothing less. It's pretty typically these three functions which basically creates a business enterprise. And this is the activity part. And then these are the component part. So there is of course a working capital. Then you need some fixed assets. Then you need some intangible assets. Then you need human or IP, so to say, intellectual property, like I said. And then of course that becomes your business enterprise in that way. Right? Now if we dive deep, what is in these different functions? In production you have R&D, then you have production, then you have operations, then you have a quality, then you have a distribution. In selling you have sales and marketing. In support, you have your IT infrastructure, your HR people, your accounts, legal, planning, management, and business relations, right? Now, and then the external part, of course, right? Which is advertising, market research, which are really support to the entire internal systems. It could be advertising is relevant for selling, then IP consultancies mostly for R&D, or your operations or quality, depends on where you are fitting in. So this is how the business works, right? So I'm sort of trying to build a bit of a foundation before I go on and talk about IP management and how to do it in technical sense. I want to sort of build some sort of foundation on the business side of the things, right? What is it that business means, and how does IP fit in those? I would like to have questions in the middle. So in case anyone has any questions, type on the chat box while I'm going through the material. I'll be happy to address that ongoing basis than to pick up in the end of the presentation. So that's about so that's how we are going to do it. So as I said, typically R&D, production, operations, quality, these are your producing activities. Selling is sales and marketing. Support is, of course, your IT, HR personnel, accounting, legal. These are your support activities, right? Now, if you think about intellectual property, like I said in the start of the presentation, it could be a lot of things, and I think Manoj also touched upon, Pankaj also already touched upon that, in the initial part of his presentation, that that there are a lot of IP. This is business know-how. Know-how means you know how to do something, which is not really if you know that this is how to done most efficiently. I mean, a lot of times it happens in R&D that you have a certain formula, but there's always how it works in all that. Sometimes you can't really document it, so that becomes your business know-how, right? Then your inventions, then your formulas, then your processes. How you are making. What is the biggest IP for, let's say, the Ford when it started? It's their assembly line sort of their processes, right? So their biggest strength was their process, right? Their device and the softwares. If you're using some sort of utilities or softwares to do that, if you're using a third-party technologies, I mean, sometimes you are using a third party, which is your differentiator in your business, your unique selling proposition, as a tagline or anything which you feel that it gives identity to your product. Domain names, how you are present on digital media and on the web. Your license, it could be a government license or maybe a technology license, or let's say in some cases, like in a production kind of environment, let's say you have a license on a mine. So that is your IP, right? I mean, that is your IP, real IP, that you have a license to mine a mineral in a certain location and so forth. Customer list could be your biggest IP, which you may not be able to protect by any IP, IP rights. Of course, it could be a trade secret in that ways. Prospects, or how you are, your potential customers. Pricing information, how you are pricing your, products and services. Sales figures, financial projections, creative works like your logos or your website collaterals, or your marketing collaterals, or so forth. Business information, advertising, promotional material, and then of course there are some always secrets around the business. Let's say how you are doing certain things. So these are the IP, right? And these are the IP because of the business, right? And I think one thing that because of the topic that we are dealing with, handling and management of IP in the technical sort of environment, one thing that we have to sort of see and look at is that what is it that we are trying to protect? What IP do we mean? And as Pankaj said that, there's a famous ad, Thanda Matlab Coca-Cola. It's not always about patents. If you look at this list, invention could be the last thing that in a certain business could be relevant, right? It could be just, like I said, a mining contract at a certain site that becomes an asset for the company. So I think that's very, very important, that even in the technology space, if you have a certain license, let's say you are a licensed product from a Google and you are the only seller, so that license from the Google or a certain vendor becomes your basic IP right. So one thing that we have to be really careful, or we should be really defining at the time of doing the management of our IP for a technology firm, is to, of course, be very clear about what is it that we are talking about, right? So that's something that I wanted to touch upon and build, and then carry on the next discussion. Of course, my focus again would be on patents, how to do patent and IP audits. Of course, I'll be talking more about patents, but I think what I'm trying to sort of build on is that IP is not only about patents, it's also about a lot of other things in the business, and business is also about a lot of other things, not only the IP. Yes, in nowadays, 80 to 90% of the company's value is IP, but let's also separate IP from IPRs. So that's going to be one of the major discussion point that I will try to push in my sort of discussion with you guys. Uh, how now I'll shift the gear a bit, and then I'll start talking about patents. Of course, it's a much talked about area. That of course patent race is also happening with China and everything, right? A lot of filing from China. I mean, when I started my sort of IP career, I have always seen US by default on top of every charts, every inventions and everything. Of course, then China sort of decided to sort of take over the world, and then they have started producing a lot of patents around a lot of technologies. Of course, it's always debatable, how's the quality of China's patents and all that, but let's not go into that discussion. But I think, of course, that becomes like an indicative of the innovation and R&D centric economy and so forth. But what is the real value of a patent? I mean, let's look from that perspective, right? So, from a company's point of view, first you have to the value of a patent, or how it helps in a business is by three things. One is you commercialize the invention which the patents protects it. For example, if you have a built technology or a service, product or a service, then it should create a clear differentiation, right? It should create a differentiation in terms of your product, in terms of your service, and then there has to be an element of the invention which gives a certain benefit to the end user or the end client, and of course builds your reputation or your technology capability and so forth with your end client, and that of course leads somewhere. If you create that differentiation, it should either sort of affect in your increased margins or increased market share, or both in ideal case scenario. So one thing that you should be also, so the first objective of a patent could be to commercialize the invention which it really protects. And then of course using patent which is a negative right, you can of course stop your competitors to do that same thing, so that you can actually continue to create that differentiation and continue to be increasing your market margins and market shares and so forth. Now the second objective of patent could be the license of the invention. A lot of business models nowadays are also around licensing of the invention. I mean, a lot of companies, I don't know, one of the good case studies is around ARM. ARM is ARM, which is one of the chip manufacturers for your phone. A lot of phones are having ARM chips, and if you think about it, what they do is that they license out their technology, they license out their entire patent, sort of pool or whatever they have generated to a lot of other different companies. There are numerous models like that where you are sort of out licensing your technology, right? Where you are out licensing a technology for others to commercialize, or others who are currently going to be the end users. There are a lot of companies around it. Qualcomm is also one of that, where they get substantial revenues out of their patent assets and so forth. And Microsoft is one of the good examples. While we feel that Microsoft have lost the battle with Android, but Microsoft made a decent amount of licensing revenues from their patents by licensing out to the Android or the Googles, because they were generating a lot of revenues around their patents by just licensing them out, right? So these are the first two objective of patent. Third is of course to monetize the invention. You sell your technology. A lot of companies focus on building technologies and then selling it out, or the other way around could be that you have created a technology which you feel that it was not of use to you, or you have already extracted the value out of it, and then you want to sell a technology. So the third way you can sort of extract value from a patent asset is of course by monetizing your patents or inventions, where you are going to others to commercialize it. Sometimes people acquire or would like to buy your patent or so forth to use it defensively. or you can also monetize your patents to others who are probably using the inventions that that basically is protected by your patent, right? So, but end of the day, patents has ideally these three objectives. Create a differentiation, uh, get you the revenue of license, that you can license it to a lot of people, or you just sell it out, or you give an exclusive license and then let the others do the value extraction of the patent. So one thing that needs to be very clear in our heads, that when we are thinking about patents, these are the three facets of the patents that is there. And I think if you go back, and I'm sure it must have been covered by the other speakers in the forum, that why patents are like a negative right. It's not. It's your duty to, of course, enforce it. It's like having a piece of land, and it's your duty to make sure that nobody is coming and building upon something on your land, than that government or someone will proactively comes and tells you that, look, there's been someone who is building on your plot or whatever. So just try to intellectual property and property, I try to relate somehow just to make that context in the head, right? So if you want to sort of think like that if you have a piece of land, you want to either live on that land, you want to generate rent out of that land, or you want to sell it to have certain profits, or certain way that you can generate some capital returns on that. Other than that, probably there's no of course sense to own a piece of possession which don't create any three of these things for you, right? All right. So now, what is portfolio balancing, right? A lot of, I think that's also something which was given to me as a topic about portfolio balancing. And if you see around news and around big giants, of course, it comes in the news. So I've started to sort of build on that only. That if you see, there is a lot of companies like Google, Facebook, Microsoft, Uber has done this recently, that they have been trying to do this industry patent purchase program, right? So basically, what they would like to do is to enhance their portfolio, looking out for patents which may add value to their portfolios. And also, a lot of times, if you look at the patent data, they are also at the same time letting go of a lot of inventions. They are either not renewing it, as Pankaj said, that during the prosecution, once you are granted, then you have to pay renewal fees every year. So a lot of times companies are also letting go of their patents in order to save the cost, or they feel that there's no buyer, there's nothing to do with it. Let's save the cost by letting it go, right? So of course, portfolio balancing is a very, very important activity, especially when you look about in the technological space, because technology also gets obsolete very fast. So that's where patent portfolio balancing comes in. And as I said, for bigger companies, it's like a very institutional, very big exercises, which is visible on social media, on the news items, there's on the website, they have certain formal programs to do that. But basically what they're trying to do is that, of course, they want to spread their risks. But as it is that, a lot of times they're holding patents to have an influence on the market and so forth. So they want to create that or to remain in that control all the time. So I think why portfolio balancing is required is, of course, is to look at what is going on. And I'll be talking about in the further how we actually do it, what are the steps to do it. So of course, when we think about how to do it, of course, we look at R&D expenditure on patent filings. Portfolio balancing is not only about letting a patent or patents go and not renew them, or it's also not only about purchase what is not with you and you feel that it is valuable for you. It's also about R&D expenditure on the patent filings. For smaller companies, they want to see, okay, what is it that how much they're spending on R&D, how much they're filing a patent. My typical recommendation has been always that if you are spending whatever you are spending on R&D, keep a 10% of that particular amount as an IP budget, or not patent or whatever, just as an IPR budget to protect whatever you are doing. It's like, building a house and spending a bit of money in terms of the gates and the security systems, right? So I think that's how portfolio balancing occurs. And the second is, of course, the scale that you have to look at. Okay, you of course want to look at what is the scale of the portfolio which is there in the industry. How much your competitor or how much you need to really have your portfolios and these things. Then the third thing is diversity. You have to have a diverse. It should not be only limited to one invention or one part of your product. So you see how you can have a diversified portfolio around your product or whatever you are trying to create as a technology or product. And then the timing, in terms of if you have already already entering in a late sort of technology. I don't know how many of you have looked at the hype curve, technology hype curve. So there's sometimes that people have already lost the battle or they are already late in the battle. So timing is very important in patents. Patents are always ahead of market, and the company has to be very clear and very much planned about when they are doing this portfolio balancing. They should be chalking all their plans around portfolio balancing and so forth. In terms of how the portfolio management timing, when the patent should be filed, and how to expedite it. In some cases, like Pankaj has already covered, that even in India you can actually expedite your examination, because maybe if after 4 years the technology not exist or there is no one to take it, so you would like to have a strategy or have a balanced portfolio around your technology that you are building. So these are the now I'll talk about, of course, now what I've been talking about, the context of this. Now let's talk about what's the step of it. What how do you really go about this? If you really think about it, it basically sort of is four steps. One is strategize. First step to portfolio balancing or portfolio creation is to strategize. Okay, think about how patents or IPRs going to help you. It could be, of course, I'm going to talk about more on patents, but it could be, like I showed you the comprehensive list of IP available in the business. It could be first to sit down and really plan about, okay, how and what IP portfolios that we need for an increased ROI. ROI means return on investment. If you are going to invest anything on your IPRs or protecting your IPRs, how much you are going to spend, how much is it that you can, so that's first step, strategize. Then the second is invest. Once you strategize, okay, this is what we need, then we look at investment. How much investment do we need? What do we have already, and how much to invest more on that? So let's say if you have a 10 patent applications already pending, you really think about, okay, should I really go forward? Should I invest in these or so forth? Then you look at protection. Like I said, IP or IPRs are like a piece of land. It's your job, it's your duty to make sure that nobody is infringing. You have to see, who is using it and how you can, by stopping them or by collaborating with them, whatever the case may be, how you can leverage your IPRs in your favor. So third step is protect, which means infringement tracking and the intelligent renewals. Of course, intelligent renewals in a way that if you are renewing, if you have some patents which have no use, then you should think about what to protect, what not to protect. Sometimes a good strategy is not to do anything or not to spend on money. So that is the third step. And then the fourth step is monetization, right? I mean, if you feel, okay, there is certain things that I want to let it go and I want to monetize certain of my assets, then it could be that, okay, let's monetize it. And it could be in your strategy if in case you are building and using it in the three other areas that I've talked about. If it is monetize, could be a license. The last step could be create differentiation or commercialize it, license it or monetize it. So the last step could be either of the three areas or the three ways that you can leverage your IPR, right? Now, how to basically do this, right? And these are set of questions. I mean, these are very, very high level questions, but let's say, what are the questions that you need to ask in these steps? First, when you're strategizing, then you have to think about what is my current portfolio status? What technologies I'm strong at, what stock technologies I'm weak at, what is it that I'm really using, what is open source, what is not open source, what is it that I have done, is my portfolio or my IP portfolio is a young, or it's already technology is already matured. What are my competitors doing? What is their current R&D focus? Where they are going as a market? Who are possible new entrants? What are the new technologies that are coming in? So look at the business side of it. What are the potential innovation in the adjacent areas that you can sort of think about? Is your technology space is growing very fast, or is mature? So think about from that technology point of view. And then to do that, basically, there are certain tools available. Typically, look at landscape analysis. It's like a high-level analysis on the patent data, or your R&D, or sorry, competitors' patent data, and so forth. And do a segmentation of the portfolio. See, okay, this. So if I have a pool of 1,000 patents, then we see, okay, what is going on? Who are the new entrants? By looking at the new filings, and what kind of technologies that they are in. Segmentation and all that. So that's the second. So these are the two tools that you can use. So I'll not go within the tools. I'm sure it will deviate from the topic. But so landscape analysis, it's possible tool for you to strategize. Then the second is investing, right? And how to think about, okay, what are the questions that you can think about investing step? So it could be, how does my market look like? Am I investing in the growing market or technology? Should I acquire IP or develop IP? Like, which are, and then if I need to acquire IP, which are the top patents for acquisition? Are there any small companies? I'm sure you must have heard about Apple or Google, taking up companies very, very early, right? Because it also part of their investing and their, strategy that, okay, this technology where we need to get strong at, will probably acquire a smaller company. Then the question is about develop IP. How can I help my inventors find research directions quickly? Patents and a lot of tools can also are available to also look at help your R&D team to find a direction, right? Okay, this is what people are doing. This is what people are talking about. In my industry, pollution is the biggest problem. So maybe we should be talking about biodegradability of certain things. So those are the things. Then you have, if you have strategy around that, then you can also find patents and technologies which can actually give it back to your R&D teams, and they can pick it up quickly. And then the second thing, when you are developing IP, patent data can also be used for targeted hiring. So okay, so let's say if you have strategized to develop a certain new area or new technology, then you can also find from patent data or the landscape analysis and so forth that who are the top inventors in that space, which university is basically very active in that space, and probably going and collaborating with them could be a. So that is your investment part, right? So first, like I said, first strategy, that looking at what is it that we need and strategize around it, and then we do this investing stage. And typically in the investing stage, of course, landscape analysis, that you can go a little bit down deeper. Look at if the strategy was a 30,000 feet view, then you go down to 3,000 feet view, and then see a bit more granular. What are the small companies and what are the inventors and so forth. Then you look at due diligence on the patent acquisitions. Then you look at some statistical tool to sort of get to that data, which I'll quickly sharing, and also sharing, some of the experiences with one of the tools that I sort of seen. Then you also talk about expert, then you also talk to, researchers or the top technology developers in that space to take your patents or whatever patents that you have found, or your own self patents or applications, to take to them and understand what they feel about that, how strong it is, how is it going to be helpful for you in achieving those 3 objectives that we have discussed for patents, right? Then basically it comes to the protecting stage. Then basically you look at, okay, who is infringing my portfolio, or who could potentially infringe my portfolio? Which patents are my really assets, which are my intellectual assets really, which is actually I'm using it for my commercialization, licensing, or monetization. And then also look at, how are you protecting your assets which are really, really good, and you don't have a risk of unintentionally they get dead or they get abandoned in the process. Of course, it is relevant for the bigger portfolios, but of course it comes with protecting that. You have to be very taking much stock on what you have already decided on investing stage. Now it's the time to protect that stage. And to do that, there are certain tools like evidence of use. Evidence of use is basically an analysis where you map or chart your patent claims against the product, so that you can see, okay, if this competitor is basically using my invention or a patent, then how is it that they are related, and how is it that they are using this inventions, my invention, and so forth. And then you can do some sort of statistical assessment around how to sort of so depending on the portfolio size, you choose, should I do it statistically or should I do it there are ways to do also statistical assessment to identify who could potentially be infringing your portfolio, which I'll be talking about, called citation analysis and so forth. Monetization, of course, like I said, it could be read as commercialize or license or monetize. And basically, in this step, basically you think about, if you decide to monetize or sell your patents, then you think about, okay, who are potential licensees, who do I sell to, who do I, who could be a broker. It's a very niche selling. How do you market your technology? It's not very easy to sell a patent asset, so to say, but how can you find a potential buyer who can really take my asset? It could be even the bigger IP purchase program, but how do you market it to them? How they should be perceiving it? So that's how you sort of do that. Then basically, in the IP audit, we'll talk about IP audits, that, okay, what is IP audit? So now, so that's like I was telling, the 4 stages of these things. Then what is IP audit, right? So IP audit is basically, examination of the situation, that what is audit. So I'm trying to break it down to audit, right? So this is basically, audit is basically that how do you do this audit? So basically IP audit is looking at a systematic review of your IP, and as I said, look at increased market share, high profitability, add business value, protect business. So that's how you have to really start doing the IP audit part. There are multiple purposes, multiple types of IP audits. This could be general purpose IP audit. When you are doing this for establishing new companies, new policy standards, new initiatives, and so forth. So depending on if you are reporting to your stakeholders and so forth. Then there could be an event-driven IP audits, which is like M&A transactions. If you're raising a fund, if you are doing IP licensing or bankruptcy, these sort of events. So in these events, you do IP audits. Then there are limited focused, like where there is a personal takeover. There's a lot of transfer pricing implications on the IP. And then, of course, when there is a litigation happening and things like that, so then that's where you do this litigation preparation and all that. In real life, how to do it, one thing that I have been exploring and I have found useful was patent scoring. Before that, I'll quickly come to one more slide, which is about so citation. So I'll talk brief about citation. So how does citation work? Basically, is that So let's say this is your patent. So forward citation is, like in the research field, who is citing your patents. If you are citing yourself, if you are somebody else is citing, and who you have cited from. So from where you have learned or where you have sort of built your patent portfolio. So this is very, very important when it comes to the these things where you look at citations very, very deeply in terms of scoring. Let me come back to this one. Yeah. So scoring is basically, scoring is one of the very quick ways to look at your portfolio, right? And it saves time in sort of doing this, what I've been telling, how to balance your portfolios. So typically it could be, when the scoring happens, there are 4 basically values that could be used: the citation quality, the market quality, how, where it has been protected, legal quality in terms of legality, how strong it is, and then the intrinsic quality, like how strong the claim is and so forth, right? And then basically, if you see, these are some of the, this is how you sort of score your patents and portfolio. And this is one way I've found this. I've been using this tool called Paxier 360 recently, and this is a very good way to sort of score your portfolio. So you can look at number of forward citations in your patents, how many in last 5 years, how many citations that you have received, how much generality. So generality and originalities are the 2 metric which there is a big paper around, how you can assess a generality and commonality of a patent, how many backward citations have been there, how many examiner inter citation ratios, and so forth. So this basically makes your citation quality. Now, market quality is basically the countries where invention is filed and actively present, like countries where there is a higher weightage, if it is, how many countries the family is expanded and so forth. Then the legal quality is, of course, if it is, dead or alive, how much life is left, if there has been any oppositions and so forth, if there's an ongoing collateral, is there, if there's a document quality, like, how many co-applicants are there, how many unique technology CPC, IPC digits are there, number of total independent claims, if it is in the standard essential patents and so forth. So these are some of the value indicators that you can use statistically to sort of do this. And as I said, I've been using this tool to do this, but you can also do it manually. It's not a, it's of course, if you're doing it for a limited set of patents, you can find it out and sort of, manage your portfolios accordingly. Then I'll come to patent watching, where I'll be, one of the very critical activity in the real world is, of course, looking at what I've been talking about, the protecting stage, where, we have been talking about protecting of the IP, that you have to also keep a watch on your area. So it could be a technology watch, what's going on in a particular technical field. If it is a competitor watch, what is your competition is up to. Then you can also look at some of the patents which are very important and critical for your business, and look at, okay, what are the legal status of those. So you can keep a check on those sort of things. Then, of course, look at the money effective market watch, not only patents, but you also, look at how much research and, happening in a certain space, and how much patent is coming out of it. Then you look at infringement watches, who are potential, patent infringers on your portfolios and so forth. So, but it's very, very important to have a watch. that unless you watch it, you don't know what's going on in your sort of space. How you can do a patent watching, of course, by subject matter, looking at newly published patents and applications. And if you are specifically interested in a certain country, you can restrict it by countries of interest. Check at developments in a selected field of interest. See possible competitors are up to, and then you can also, like I said, by applicant name. So there are a lot of tools available commercially, or you can also use some free tools available on European website or Indian patent website, or there are multiple tools where you can sort of do that. Then, of course, monitoring early stage infringement risk by looking at the citations of your patent data. And of course, one of the things that in the protection stage, you can also oppose patents in that ways. So that's also there, that you can oppose certain patents of your competitors by watching and looking if they have also created some patents which are potentially going to stop you from doing your business. So that's also a very important part in the watching exercise. Citations, as I've been discussing, that how the knowledge flows, that if you are filing a patent, then how others are citing, and how your technology is being used by the companies or the technology players in the same areas. Yeah, so this is how it is. I mean, forward citations, which are to simply remember this concept. Backward is something which is older than your patent, and forward citation something which is newer than your patents, right? And which are basically referencing your patent. I think that is it from my end. I was expecting some questions so far, so I've kept it short. So I'll keep it open now. Jazila, I think I've finished very early. But in case any participants have any questions, we can pick it up.
We have received one question, and it goes like this. Is there any distinction between an IP management professional and an IP attorney?
IP management professional is see, if you talk about in the IP function, so IP management is basically where so IP attorney is a qualification. Let's say if the IP attorney is that you have to have a technical degree and a law degree, then you become an attorney. So let me define these two things, right? So IP attorney basically means that you have a technical degree and then the law degree that you are basically entitled now to basically practice on the IP matters. Of course, in India you have to also get to have an agent, in order to file a patent application, right? So if you have these three, you have a technical degree, you have a law degree, and you have a patent agent, then you are an attorney. The management IP management point of view, or professional, it could be a person who has a strong. So there are two functions of it. One is a person who is managing the administrative part of the IP. So let's say, looking from the filing, then it goes to patent office, then so the management part. If you are talking about that management part, then for that you could be a person who has a sound knowledge of IP processes. You are fine. You are good to go in terms of IP management professional. But if you talk about what I've been sort of trying to discuss about management of the professional, it's good to have a business sort of understanding or a big understanding of the IP and how it works. You may not necessarily be a lawyer, but you can still be a management expert or an IP management professional. So that's how I can differentiate between these two functions, or these two sort of career options, if you call it.
Okay. Thank you. So I hope that's clear. And we have a question which says, what do you mean by IP engineer?
So IP engineer, I am not a lawyer. I do not have a law degree, and I have an engineering background and a management degree. So I am so engineer is basically, if my job is to basically understand the technical part of the patents or the technology and advise the clients or advise the company how they can really protect that technically, because patents is a lot about technicality. I would say 80% is technical, 20% is legal. You must be good with technology in order to really get around the patents technicalities in terms of how to get around the novelty objection or the obviousness objections from the patent office. So that's where I have been sort of telling I as a person have more expertise on understanding the technology and advising the companies how to basically protect it than to sort of get into the legal side of things. So that's why I say myself an engineer, not an attorney.
Okay, that's nice. I hope that was a good example. And with this, we will move on to the end. Mr. Pankaj, sir, are you online? We'll move on to the end. Yes, with this, we are winding up with session 3. I hope it was very informative and all the questions are cleared. And if you have further questions, you can write back to us. And also, we have shared the PDF materials for you in the file section. You may download it. And if you have further questions, you can surely approach our speakers, or you can write back to us on IFERP@webinar.in. And further questions, usual questions regarding the certification part of it. The procedure on how to download the certificate has been given. In case if you're a new person who does not know how to download. Other than that, if you are already a member of IFERP, you can log into the account and download it from the certificates and rewards section. So thank you both of you for this lovely evening and for this great presentation. Thank you for joining us in this busy schedule. Thank you, both of you. And tomorrow we'll be moving on to session 4. And thank you to all the participants who joined us in the live webinar as well as on YouTube. And if you haven't registered, do register for session 4 and 5. And we'll be beginning our next webinar from August 14th, which is on PhD end-to-end assistance and guidance. So see you tomorrow at same time with session 4 with the new speakers and a new topic. Thank you so much, both of you. Good day to all.
Thank you. Thank you. Bye-bye.
Bye-bye.